and thank you for joining us. My name is Katie Perez, and I'm a Senior Associate here at Scott Legal PC. Today, we are going to spend some time talking about the primary employment-based green card categories. This webinar will compare and contrast the requirements for each category and help you identify the most suitable option. So just a few things before we get started. Some of you may know that the firm was founded on an E-2 visa several years ago. Our founder, Ian Scott, is in the U.S. on an E-2 visa and has been on several different visas, including an F-1, a TN, B, and H-1B. Scott Legal PC is a full-service immigration law firm, and we offer immigration services in several different areas, including E-2, E-1, TN, L-1, family immigration, national interest waivers, EB-5s, extraordinary ability visas, and more. We will continue this webinar series doing at least 2 webinars a week on different topics, and at the end of this webinar, we will send out several useful tools. We'll send you a copy of the PowerPoint presentation from today, a link where you can download guides that go through the visa options in more detail, and also a link where you can sign up for additional webinars. This webinar will be recorded and available on YouTube. We will also send the link for that. We encourage you to subscribe and hit the notification button as we regularly upload immigration videos on a wide variety of topics. We'll also send you a link where you can arrange a consultation with one of our experienced immigration attorneys if you would like to discuss your case in more detail. If you have any questions throughout the presentation, please put them in the chat box and we will address them at the end of the presentation. So today we are very fortunate to have our partner, Kelly Weiner, here to present the presentation. Kelly is a partner here at Scott Legal and has extensive experience processing each of the green card categories we will discuss today. So without further delay, we will get started with the webinar.
All right, thank you, Katie. So we're going to get started just talking about a brief overview of employment-based green cards in the United States. So we'll touch a little bit on the EB-1A, the EB-5, and we'll discuss the EB-2 and EB-3 in much more detail in this presentation. So the EB-1A is an extraordinary ability green card, and this is for people who have achieved sustained national or international acclaim and risen to the very top of their field. So this is quite a difficult bar to meet, and is, an option that's really reserved for, kind of again, like the small percentage that's risen to the very top of their field. The way that you demonstrate that you, meet the EB-1A criteria is either showing one kind of major award, like if you've won a Nobel Prize, or much more commonly, people will qualify based on showing they meet at least 3 out of 10 criteria. And these are things that are kind of all related to proving your extraordinary ability. So things like prizes or awards, that can show your sustained national or international acclaim, memberships in associations that require outstanding achievements of their members, major original contributions to your field, high remuneration, leading or critical role in distinguished organizations. So other things related to that. There's also a few related to the arts, as the EB-1A covers, sports, athletics, education, arts, business. So any kind of area that you can define to show that the person, within that area has risen to the very top of their field. And we do have kind of a separate webinar that goes over the extraordinary ability categories, both non-immigrant temporary visas and green cards like the EB-1A in more detail. The EB-1A, the way that it works is you submit all that proof that we talked about that shows you meet at least 3 out of the 10 criteria. And then they will assess that to see if you have provided that documentation. And then they will do kind of a totality assessment to see if, looking at all of that in totality, you seem as though you're an applicant who's risen to the very top of their field. Just to briefly touch on the other kind of EB categories here, we have EB-1B, outstanding researchers and professors. So often people who are coming to the US for kind of positions with universities. EB-1C, multinational managers or executives. So very common for people to transition perhaps from an L visa. If they came as a manager or executive and were a manager or executive abroad, the criteria for that are quite similar. EB-2 and EB-3 we'll talk about in more detail. Just briefly, EB-2, you qualify for this if the job that you are applying for or that you're going to hold in the United States requires an advanced degree, which means a U.S. master's degree or higher. or its equivalent. Equivalent would be a U.S. bachelor's degree plus 5 years of progressive post-baccalaureate work experience. You can also qualify for EB-2, without the education requirement showing you have exceptional ability. Exceptional ability is kind of a lower standard than extraordinary ability, but you're showing you meet at least 3 out of 7 criteria. Things like 10 years, letters documenting 10 years of full-time employment, a license, in your field. So things of that nature. For EB-2, there's two ways you can, qualify. One is the national interest waiver. And this is where you are working on an endeavor in the United States that has substantial merit and national importance. You show you are well positioned to advance that endeavor. And so then, as a third step, you argue that the government should waive the normal requirement for company sponsorship and a labor market test, because on balance, it's beneficial to the United States. We do have kind of a separate webinar on the national interest waiver, and it has many benefits. For example, you can self-petition the way that you can for an EB-1A. The other option for EB-2 is company sponsorship, and that's what we'll talk more about today in the coming slides. This is where a U.S. employer will sponsor you for a job that requires, a U.S. master's degree or equivalent or higher. The EB-3, this can also be, the U.S. company applies for you, to get your green card. For these categories, there's 3 subcategories. Professional, that means the job requires at least a U.S. bachelor's degree or higher. Skilled worker, meaning the job requires at least 2 years of education, training, or experience. Or unskilled workers, where it requires less than that. And there's kind of less green cards available in those unskilled worker categories. EB-4 we won't talk about, but has, kind of applies to kind of different categories, for example, religious workers. And then there's EB-5, and this is an investment green card, and it's based on investing either $800,000 or $1,050,000, and then the creation of 10 full-time jobs. EB-5 is quite a long dated, green card option. So first you have to invest that capital, and that can be invested either into a direct investment. So people who may be starting their own company, or, with partners, or a regional center, where you're kind of making an investment into a regional center that will deploy that money often for kind of large scale infrastructure projects. And that can be something that is, helpful for people that maybe don't want to run their own company, but still want to apply for the green card. The EB-5 has kind of 3 steps to it. So the first step is you file the I-526. That's where you provide the source of your money, which is a very onerous requirement where you have to provide a lot of documentation, many years of tax returns, proof of the source of funds, and that the money has been deployed. That can be filed if you're in the United States, and the category is current. You can concurrently file that with your green card application and I-485. They are taking several years to be approved, even in that first step. So the I-526 itself could even take 4, maybe even 5 years. And then once that is approved, then the green card can be approved. You get a 2-year conditional green card. And then at the end of the 2-year period, in the 90 days prior to the expiration, you'll file what's called a Form I-829, and that is where you're proving that you've created the 10 full-time jobs and sustained your investment. And then once that is approved, which can be another few years, then you'll finally get your kind of 10-year green card. So the EB-5, while it can be a very good option for many people, and you have to just prepare yourself that you will be waiting kind of for those longer time frames. That being said, the ability to concurrently file the green card application along with the I-526, is a very attractive option, especially for people who are already in the United States in a valid status that allows them to apply for adjustment of status. We can go to the next slide. All right, let's talk a little bit more about the PERM, EB-2 and EB-3. So what is the labor certification process? It's also called PERM. So the labor certification process is the first step in a company sponsorship of a green card application for their employee. And this is a 3-step process, and the PERM, or the labor certification process, is by far the longest, step in that process. For the PERM, the first thing you're going to do is draft a PERM compliant job description. And what this means is that you have to refine the job description so that the requirements only ask for the minimum requirements to do the job in a reasonable manner. So while most job descriptions will have kind of aspirational things they want, great communicator, preferred qualifications, for the PERM process, the government wants the employer to draft a job description that is as open as possible to US workers. So they really want the employer to consider, what do you need at a minimum level for the person to do this job in a reasonable manner. So that might be a bachelor's degree and 2 years of experience. It could be more than that, but the company, if it's far above what the government considers normal, the company will have to justify that requirement through a business necessity argument and provide more information. You also have to consider that the requirements cannot ask for anything that the employee did not already have when joining the sponsoring employer. There are some kind of caveats to that, but for the like let's say you've been hired as an accountant and they want to employ you for the, perm job as an accountant. They can't kind of use the experience that you gained with the sponsoring employer. You can only look at the experience you gained prior to joining the employer. If the perm job, the green card job that you're being hired for in the future, is substantially different than the job you're currently doing for the employer, then sometimes you can use that experience. But you have to make that specific argument, and that's more of an outlier type of situation. Once the job description is drafted, then you will file with the Department of Labor for the prevailing wage. This is the wage that the employer will be required to pay once the green card is granted in the future. So it's not something that they have to pay right now, but it will need to be paid in the future, and the company will need to provide financial documentation to show they have that ability to pay it. The prevailing wage can take about, 6 months, to be, issued by the Department of Labor. And once you have that, you can go ahead and start the recruitment process, also called the labor market test. This is where the employer actually has to place advertisements, and the type of advertisements they have to place are, kind of regulated. So you can't just place any advertisements. There's certain timelines. You have to place, for example, a 30-day job order with the state workforce agency and the state where the employment is happening. You have to put a notice of filing in the physical place of employment. You have to submit a Sunday kind of newspaper ad in the newspaper of general circulation for the location of employment. And then if it's a professional position, or above, you also have to submit three additional, types of advertisements, and you choose from a list of 10 things like posting on the employer's website, local newspapers, radio, TV, job search websites, things like that. Um, if you get through the labor market test, and you have not found any willing, qualified, and available U.S. workers, then you can proceed with the labor certification. If the employer tests the labor market, reviews resumes, and they do find willing, qualified, and available U.S. workers who meet all the requirements, then the process would have to stop, because you've tested the labor market, you've found there are U.S. workers who could do this job. The employer does not have to hire any of those workers, but it just means at that time they cannot proceed with sponsoring the employee for a green card. But assuming that the labor market test, you do not find any willing, qualified, and available U.S. workers, then the employer will go ahead and file a labor certification with the Department of Labor. The labor certification, says, here's all the advertising that we did, provides information about the company, information about the job, information about the employee to prove that they meet all the qualifications. And then that will process right now, it's about 16 to 17 months that they are reviewing these cases. So it is taking quite a long time. The case can either be approved, also called certified, it can be denied, or it could be audited. If it's audited, what this means is the government says we would like more information to prove that you followed all the requirements of this process. So they might ask for things like the resumes of the people who applied for the job, any evaluations the employer did to determine that they weren't willing, qualified, and available, other documentation about the company. If you are audited, you have to submit the response within 30 days, and then the government will generally submit a response several months after that. There are certain triggers that can make it more likely that your case is audited. For example, if you require a foreign language and it's not a job where that's clearly obvious, like a Spanish teacher. So if it's, for example, like a business role and the person deals with a lot of people who speak another language, there's a very high standard that they use to use a foreign language requirement. Additionally, any requirements that are kind of outside the normal, what they consider to be normal for the occupation. So if the Department of Labor views it as requiring 2 years and the employer requires 15 years, that's something where they might be more likely to audit you. Um, all of this PERM process is filed with the Department of Labor. It's not with U.S. Citizenship and Immigration Services yet. And as I mentioned, the timing is quite long, just based on processing times, with the prevailing wage taking 6 months and the labor certification taking 16 months. You're already essentially at 2 years of just processing time, not even including the 2 to 3 months for the labor market test or the drafting of the job description. That's to say that when you're doing a PERM, long-term planning for your employee is very important. You want to know what is their underlying status, and we'll talk about that more later in the presentation. Once you get to the stage where the labor certification is certified, it's valid for 6 months. And during that time, you need to file the step two, which is the I-140. This is a petition that the employer will file that says we want to sponsor, this immigrant, for a green card. The employer must provide proof that they have the ability to pay the prevailing wage. If the company is very large, has over 100 employees, sometimes instead of financial documents, you can provide things like a letter from the CFO confirming the ability to pay. And then you also have to include proof that the employee meets all the requirements. So, for example, if the requirement was a bachelor's and 2 years of experience, you would include that degree, the transcripts, and any experience letters that show that the person had that specific experience and earned it before joining the company. The I-140 is the one step in this three-step process where there is an ability to pay to get a faster response. So you can pay an additional fee to get a response within 15 business days. That can be an approval, denial, or request for more evidence. If it's a request for more evidence, you'll submit the response, and then they should issue a final decision, usually within 15 business days. Once this is approved, then you're at the step of the green card, and we'll talk more about both of these options. But one important thing to know is you have to consider whether your priority date is current or not to determine, whether your green card application is going to proceed at that time. So for the past couple years, EB-2 and EB-3 have both been backlogged. This month in April 2026, for the first time in a very long time, they're both, current for filing, meaning if you are in the United States and you have this approved I-140, you can go ahead and also file your green card application. However, you need to consider, what is your priority date? Your priority date is set on the date you file your PERM. So, kind of the long processing time for PERM, the benefit is that, once you get to the green card stage, hopefully, the priority date would be current because you would already have been waiting for quite a while. Family members can join your green card application. That includes your spouse and any unmarried children under 21. We can go to the next slide. All right, let's talk a little bit more about step three, the green card step of the PERM process. And there's two ways to approach this. One is an adjustment of status, and one is consular processing. An adjustment of status is available for people who are in the United States in a valid status that allows them to adjust status. So, for example, let's say you're here working for your employer on an H-1B. Most commonly in the PERM process, companies are sponsoring an employee that's already working for them. So that means most of the time, the adjustment of status is kind of the process that people will go through. This is where you will file an I-485 with U.S. Citizenship and Immigration Services. The benefits you get are once it's filed, you kind of have this ability to remain in the United States, kind of based on the pending I-485. You also can file for work and travel authorization when you file the I-485, and that is for you, your spouse, your children. At the end of the process, most applicants will have an interview with a consular, or I'm sorry, a USCIS officer who will kind of verify the employment details and check for any admissibility issues. One important thing to note is that when you file your I-485, for many people, it means they cannot depart the United States until they get travel authorization issued. There are exceptions, very limited exceptions for people who have valid H-1B or L-1 visas, where they are permitted to kind of travel during the adjustment process without issue. But let's say you're here on an E-2, or let's say you're here on an O-1. Once you file your I-485, you cannot travel outside the United States, or you will have abandoned your petition. The travel authorizations right now are unfortunately taking quite a long time. It's also important to note that if you do get your travel authorization and travel, it is always discretionary whether the government allows you to re-enter. So historically, risk of travel, if you don't have any other, immigration issues or criminal issues, and you have an approved, travel authorization, historically it's been very low risk to travel. That being said, it is discretionary to be granted re-entry, and that's something where we have seen, at the border, kind of different officers sometimes reminding people that it is discretionary, and so being a little bit harsher at the border. So it's your choice whether to travel or not, when you have your green card application pending. The other option for getting the green card would be consular processing. And this might be, a better option. Let's say you're here on an E-2 and you just cannot, kind of wait in the United States for the travel authorization. You have, family or business obligations abroad, you have to travel. At that point, once you get your approved I-140, you may choose to get the green card through consular processing. This means that your approved I-140 will be sent to the National Visa Center. You will also get a welcome email, and then you'll submit what's called a DS-260, which is a form with a lot of biographical information about you. You'll also submit supporting documentations like your birth certificate, police certificates for countries you've lived in, marriage certificates, other kind of dependent documentation. The National Visa Center will review your documents and then send the file to the U.S. consulate, either in the country where you're living, or if you're living in the United States, the country where you were living before you entered the United States. You'll attend an interview at the consulate. If you're approved, you'll get an immigrant visa stamp in your passport. It's valid for 6 months. You have to enter the United States during that time, and then the green card will be mailed to you after you enter the US. All right, so let's talk about who can pay for the green card fees. This is a very common question we receive. And for policy reasons, fees related to the PERM process, legal fees and other fees have to be paid by the sponsoring employer. They do not want to set up a system where employees can go to their employer and say, please sponsor me for a green card, I'll pay for everything. So for that reason, the employer is required to pay for the PERM process. If there is kind of, fees they have to pay to place the advertisements, the employer has to pay for that as well. Once you get to the stage of the I-140 and the green card, then either the employer or employee can pay for that. All right, let's talk a little bit about dual intent, because when you are applying for a green card, it's very important to know, what type of, if you're on an underlying visa, what type of visa is that? What are the standards for non-immigrant intent for proving that you have, residence abroad you don't intend to abandon, and how will that, impact your green card application? So many non-immigrant visas do not allow for dual intent. It means they do not allow for you to have a temporary visa and also have the intent to, file a green card application and remain permanently in the United States. Um, However, there is a few visas, the H-1B and the L specifically, that in the regulations state, it is okay to be here on this temporary visa and also be applying for a green card. So if you're on an H-1B or an L when you're going through the green card process, often a lot of benefits in the sense that you don't have to worry about kind of visa renewals. You can travel freely if the adjustment of status has been filed. The O is listed here. I would consider it's not as permissible as the H-1B or the L. You can't kind of travel during the once the I-485 is filed, but it is almost what we'll call like a quasi dual intent green card. I mean, quasi dual intent visa, where the standard to prove that you intend to depart is a little bit lower. And in the regulations, it says, if you have an I-130, an I-140, an immigrant petition pending, that's not a sole reason to deny the O-1. That being said, it does not have the same benefits as the H-1B or the L. And there's many other visas like the TN, the F-1, where there's a very high standard for non-immigrant intent. So to qualify for those visas, you have to prove you have a residence abroad you don't intend to abandon. That doesn't mean that you cannot apply for an adjustment of status if you're already in the United States on a TN, but it does mean you have to think strategically and carefully about, kind of the whole entire process, visa renewals, and where you are physically when you make the final decision about what you'd like to do. Okay, so let's talk about some considerations when moving from a visa to a green card. So you always want to think about timing and that underlying visa status. So as I just mentioned, there's certain visas like the TN, like the F1, where, once you have an immigrant petition filed, it's going to be much harder to extend those visas, because they may not believe that you have non-immigrant intent anymore. So you want to think about, if you're on a TN, and the I-140 is going to be filed and you're going to have to renew in the next few weeks. Perhaps you renew before, any I-140 is filed. You also need to think about, do you want to adjust your status in the US or get that green card through consular processing? So if you're someone who needs to travel a lot, and you can't wait for travel authorization and you're not on an H-1B or an L, or you won't be able to keep those, kind of valid throughout the process, consular processing may be better for you. If your entire life is in the United States and you're living in the US and your family is there, an adjustment of status might be better for you. You also want to think about your family. So do you have children, that also need the green card? So you want to consider, filing early to avoid any issues because your kids will age out. So if they, turn 21 and you're not at a certain stage of the process, they would no longer be able to join you on your application. Okay, so what should you consider before the interview? So, if you're doing an adjustment of status or you're going through consular processing, in both situations, you will have an interview. With a consular processing, you will always have an interview. With the I-485 adjustment of status, there are sometimes they'll approve on the papers, but more and more, they will interview you. So before you go, you want to review your immigrant visa petition and your green card petition. So your I-140 and your I-485 or your DS-260. You want to organize and print your documents to bring to the interview. So your appointment notice will have a list of what they want you to bring. We recommend you bring kind of the originals, or you need to bring the originals, but then also a copy. So things like, birth certificates, marriage certificates, you need to be prepared with those originals. You also want to ensure the medical exam is completed. If you're in the United States doing an adjustment of status, this is filled out on Form I-693. You go to a civil surgeon approved by USCIS, and you mail in the sealed medical exam. Um, if you're going to a consulate, then generally there's something called a panel physician in the country where you're applying, and you'll be required to go, and complete the medical exam with them. You also want to get updated proof of employment from your sponsoring employer, usually just kind of a letter, confirming that you're going to, hold the job that was outlined in the PERM. If you're doing the adjustment of status, you also need to prove you've maintained your status. So that's a requirement to be able to adjust status, is that you haven't violated status. If at any time in your immigration history there's been any violation, in prior years there was no grace period for H-1Bs. So if you were let go, the next day you started to be out of status, there is a provision for employment-based applicants called 245K. And this allows you to look back only to your most recent entry. And if you haven't violated status, or worked without authorization, for more than 180 days since your most recent entry, that's an exception that will allow you to still adjust status. But you do want to be very upfront with your attorney about your entire immigration history, especially if you've been in the United States a long time, just to avoid any hiccups at the I-485 stage. Also, a good idea to do a practice interview, whether it's with your attorney or a friend. Even if you feel I'm very familiar with the material, it can be a nerve-wracking situation, and you do want to just kind of practice answering some of the questions, beforehand, just to make sure that you are prepared, particularly if you get kind of a difficult officer, one who's kind of looking for any inconsistencies. You just want to make sure that you've done everything you can at this last stage of the process to ensure that, you can get your green card. Okay, let's talk about porting and changing employers. So, because the green card process is quite long, it's very common that people will ask, when can I leave my current employer? Or if I do leave my current employer, will I take any benefit from whatever stage I'm at in the green card process? So, let's say your employer has started a PERM for you and you leave before they file the PERM. You really don't take any benefit from that. If you go to another company and they're willing to do the PERM for you, that's great, but they would need to basically start all over. Um, Similarly, if you're at the I-140 stage, if your I-140 gets approved, you can keep your priority date, but again, if you go to a new employer, they're still going to have to file a new perm for you. Once you get to the I-485 stage, if you're doing an adjustment of status and that has been pending for 180 days, at that point, you start to have flexibility. So it's only at that very late stage of the process that there's flexibility. But if you do get to that point, and it's been pending for at least 180 days, you can take advantage of something called porting. And this is where you can change employers, and your new employer will file an I-485 Supplement J for you. But you can only do this if you are porting to a job that is in the same or a similar classification as the one that was approved for your perm and I-140. So, if you had been working as an accountant and you're hired by another company to be an accountant, that would be very straightforward. But, if you want to kind of take a major, change to your career, this would not be the time to do it, because you don't want to kind of get to this late stage and then have the green card denied. But what they will look at, same or similar occupational classification. They'll look at kind of the occupation codes. They'll look at typical job duties. They'll look at, kind of pay, education, experience, training required. So you do want to be careful about porting at this stage, but it is a very possible thing to do. And the benefit is that if you do port at this stage, the new employer does not have to do another perm or I-140 for you. All right. And so the last point is changing employers after obtaining the green card. So similar to, what we just talked about with porting, some people, feel they've stayed with this employer and perhaps they would have enjoyed, other opportunities, but, don't want to interrupt their green card process. And so they, want to understand what kind of flexibility do I have once my green card is granted. And so when you get your green card, you are a legal permanent resident and you are allowed to work, anywhere in the US. Hypothetically, could you quit your job and start a new job right away? You could. That being said, we don't recommend that because when you get your employment-based green card, you're making a good faith attestation that you intend to continue working for the company that sponsored you. Um, if something happens, let's say your spouse gets a great job in a different state, can you leave? Could there be reasonable explanations for why you leave? Absolutely. That being said, this is something that could come up in the future. If you do try to naturalize and become a U.S. citizen, they could look back at the timing of getting your green card and might ask you questions, just to make sure that there was no misrepresentation when you were getting that employment-based green card. So you do want it to be clear that you actually worked in that job, and that if you did leave within a short time frame, like a few months or under a year, that you have some reasonable explanation for that. All right, we've come to the end of the presentation, and I don't see any questions. So I think we can close here. Thank you, Katie,
Thank you, Kelly.
for joining, and thank you everyone for participating. Have a wonderful day.